Good morning, everyone. It is noon, so we're going to go ahead and jump in and get started. My name is Kat Klomako, and I am the lead divorce and custody coach at Peaceful Presence Divorce Coaching. Welcome to another event in the Lunch and Learn series, where we have experts come and speak on all sorts of different topics, from nutritionist support and finances to today's guest, who is going to be talking about abusive co-parenting dynamics and some survival tips for us on how to do that. So I wanted to remind everybody as we get started today that today's event is being recorded for those who can't join us live. And with that, I am going to just let everybody know that if you have questions throughout today's conversation, please go ahead and put them in the chat, and our lovely moderator, Shruti, will pass them along to me for the Q&A section at the end of the conversation. So with that, let's go ahead and get started. I am thrilled to introduce Al Huntoon, who is a family dynamic specialist with over 30 years of experience in family services, mental health, and training. He is a former custody mediator and current co-parenting specialist. And he specializes in high conflict divorce and separation, shared parenting, and complex family transitions. And before I let Al talk a little bit about himself, I just want to let you all know that the first time I heard Al speak was at a North Carolina Bar Association continuing education course. And I had never before heard a professional speak so clearly about the lived experience of abusive co-parenting dynamics so clearly before. And it was like a full body yes of, I need to be in contact with this man. This man gets it better than anybody else professionally I have ever heard speak about this. And I chased him down, and my hope is that Al can someday come to Colorado and teach these dynamics to attorneys and family court professionals here someday. So with that, Al, thank you so much for being here. I'm just overjoyed to have you. And please go ahead and tell us a little bit about yourself.
Okay. Well, thank you. That was very kind of you, and I really appreciate it. The thing I think that's important to know about me is that I was a custody mediator for 8.5 years for the court system here in North Carolina, specifically in Raleigh, Wake County. And it's the highest volume family court in North Carolina. There are hundreds of cases. It was really like an assembly line. And I mediated over 2,000 cases during that time. And so one thing that I saw, I noticed early on, was that often there are different levels of conflict, of course. Some people come in to custody mediation, and they're talking about the most important thing to them in the whole world. They're sitting down in my office just a few feet away from me. And so one of the things is, some people have figured this out. They've been doing it for years, or they're newly separated. They're parenting from separate households, and they've talked it over, and they already have a good start. They're cooperative, right? That's the expectation in our society, that people are parenting from separate households, whether they're divorced or whether they've never married, or whether they never even lived together. Because there were situations there that were one-night stands. So it's run the whole gamut. And then there's people in high conflict, and of course there's a continuum, right? There's people who are somewhere in the middle. And sometimes people are in the middle because it's just such a trying time. They're confused. It's something they never even thought about. But sometimes people are caught in a conflict because one of the parents was invested in the conflicts. And one of the things I noticed was people would come in the room, and there would be one person who seemed, calmer, more organized. They might bring some materials in or something. They had an agenda. And the other person was flustered. They were stirred up. They were anxious, maybe angry. And you get this impression. But 20 minutes later, after talking to them, you were starting to get some insight. The person who was presenting as more calm, more in control was drive.
Oh no. Okay.
I'm sorry, go ahead.
No, sorry, your video broke out for just a minute there. You paused, but the person who is presenting is more calm. I know where you're going with this.
Yeah. And the other person who is more agitated, they're agitated because they're on the defense, and they come in never having been in custody mediation before, in the courthouse, in emotionally charged situation, and they're on edge because they've been responsive to all this conflict driving behavior. And so I noticed that, and once you see that, you cannot unsee it. And I started to pay more and more attention to it. When I left mediation, I started doing coaching, and my first two clients, my first two cases, they were referred from a local family law firm, and they were examples of that. And in one case was the conflict driving parent who wanted my help in kind of managing, I would say even manipulating the other parent and getting to do stuff. And the other parent was responsive. They weren't in a relationship, two separate people. The other parent was responsive to somebody who was very rigid and controlling. And so that's what I saw. And so then I started thinking about it more, seeing it, and I started writing about it on LinkedIn. And that I got the kind of reception that you talked about when you attended that CLE. More and more people with lived experience like yourself, people with professional experience, really responding. People all over the world. Some of my most active correspondence with people in Australia. So people get it. And so now my goal is to create more of a framework with language and more aware, not just awareness, but what can people do when they're aware? Mm-hmm. And that's a challenge to figure out, because it's a lot of different professionals. People think of attorneys right away, but there's all these professionals in the ecosystem. There's the parents who are affected. There's the children who are affected. Decades of research, we know that there are negative impacts on children in high conflict situations, right? So the stakes are high in some of these situations. What I don't deal with, and just to make clear, is domestic violence. So it's up until a certain level of coercive control, manipulation. But I also have a role at a domestic violence service agency here in the Triangle. And so that's where once it's domestic violence, once there's violence or threats of violence or anything like that, that's different. The system has a way to address that. Mm-hmm. Yeah, that's a little about me. That was a lot about me, I think.
Well, but Al, I think it just shows, how deeply you understand this, which is really important, that you're doing these trainings and this education for attorneys and for, my hope would be Colorado family court decision makers like child legal advocates or custody evaluators to help them spot these patterns. And one of the things that I heard you talk about when I heard you speak was how to see patterns of litigation abuse, right? So like there's sometimes a pro se party who's the protective parent, and there's dynamics, there. And then there's a pro se party who's the abusive person. So, like you were saying, they can often present differently, and it can be hard for family court professionals to tell which one is the high conflict person. Can you talk about some of the patterns that you see in litigation abuse, especially when pro se parties are the abuser?
Yeah, definitely. And there's a term for abusing litigation, kind of consciously, intentionally. It's vexatious litigation, and it's pretty rare that it actually gets determined. Like I keep track of all the vexation litigation cases in the United States as much as I can, and it's very rare that judges find that. So that's a high standard for that. But you can see it in a lot of different ways. one of the ways that is really obvious and that people have talked about, and I've noticed it in my own coaching clients, is that there's attorney churn. So working with one co-parent, the other co-parent went through 3 attorneys and was a pro se litigant in a period of 2 years. So that's one, I think you had some personal experience with that. That's one way, that is a clear marker that I've gotten, a lot of agreement from different professionals about, is that what they're looking for is someone who will just do anything they want, basically, an attorney who will just be more interested in billing, basically, than ethics, and do what they want. And so they'll keep looking for that attorney, and they'll go through several attorneys. One of the things that I noticed and that I'm trying to build on is how people communicate. And one of the things that I saw in mediation would be people are, well, we want this, or we're pursuing this, and you'd say, who's we? Ideally people are co-parenting, and the we is the parent team, right? The 2 parents working together as a team, and it's we. It was often the legal team. People would say we, and they were talking about their attorney, their law firm, their legal team. We're doing this, or we're doing that, as if there was some sort of cohesive team, rather than a decision maker who's responsible, right? I don't care who your attorney is, they're advising you, right? They know the ins and outs of the system and the documentation and how the courtroom works. But at the end of the day, they work for the parent. They work for the party.
Exactly.
So, that was another thing that I saw. Things that you can see are a lot of enforcement actions, which are, their show cause, or things like that, where they're trying to get the judge to hold the other party in contempt for violations. And often you see they're just minor violations. They're used as a way to intimidate the other party. You see those in conjunction with motions to modify, where someone might get a custody order and 6 months later they're trying to modify it, and they file that with a show cause motion, or something of that nature. So that's another thing, is that there's a lot of these filings that people have to keep responding to. So in terms of the legal aspect, those are some red flags. There's other ones, but those are the main ones that come to mind.
Yeah. And, I was listening to what you were saying about the attorney. Abusive parties tend to find, or try to find, an attorney to be a mouthpiece for them, right? Mm-hmm. And to just do their bidding. And what I've often seen is a really helpful way to try to show the court, that this party is not acting in good faith and that they don't have the children's best interests in mind, is when they keep going back with a new attorney and they keep blaming bad behavior on their old attorney. Oh, well, that was my old attorney's advice. Mm-hmm. Oh, he told me to do that. I didn't really want to do that. I just got bad legal advice, right? Mm-hmm. That's a really common tactic that I've heard abusers try to do, is to blame their bad behavior on bad legal advice. And to me, that's just a really big red flag, and it should be seen as a red flag by the court, right? Yeah. So that's pretty typical.
That's the kind of thing that I wish I could educate judges on, talk to judges. Judges are hard to get to.
Yeah.
And there's a reason for that. And I think, in many cases, that's a good thing, that they're insulated from influence. They should be. But in other ways, there should be some influence. And this is one of the things, like you're talking about. Is this the third, the fourth attorney of this party in 2 years and 3 years? That's a red flag. Now, some, judges may already know that. I don't know, but right. That's really sticks out like a sore thumb.
Totally.
Another thing is, like, you're talking about how the person, the conflict driving person, communicates about the situation. The blame is always kind of spread around on other people. They can have an extremist, way of talking, like always or never, that kind of. You never do that. You're never flexible when I need you. You always want to change the schedule, right? That's another way. It's more subtle. That there's just this lack of nuance in the communication, and not taking responsibility.
Yeah. No, that's so true. And that sort of brings me to something I really wanted to discuss with you today, which is you have sort of this framework of the operating systems problem in co-parenting, relational versus transactional. Can you talk a little bit about that? Because I think it's a mindset shift that's really helpful for a lot of protective parents.
Yeah, and it's something that I kind of was developing a few months ago, and it just, for me, I don't know for other people, obviously you like the idea. It really stuck with me. Just kind of, I have to admit, this is a lot of me working through things and trying to figure things out, and kind of pushing the envelope on it. But one of the things I came up with, and just to back up a little bit, is you often hear people talk about the other party being narcissistic, right? It's a very common term that's thrown around. What they really are talking about is a lack of empathy. They're really saying that this person has a lack of empathy, specifically in their ability to take the perspective of the other person or the other people affected, right? They have an empathy deficit. They can't fully take this perspective, which includes like the emotional. What's the emotional impact on the other person of my actions and my decisions? Mm-hmm. So that's an empathy deficit. And so what does that lead to? It leads to that person with the empathy deficit being more transactional. They're looking for an interaction that results in a benefit for them. What often happens with the two co-parents, and it's along the lines of opposites attract, they complement each other, is the other parent doesn't have an empathy deficit. They see things relationally. They see themselves in a relationship with their children, that their actions, their speech, behavior, decisions affect their children, impact their children, that the other parent is in the children's relational system, and therefore, by kind of a distributive property of relations, the other parent is in their relational system. So what they do is their operating system is relational. This will be relation building. I need to do something to repair or maintain the relationship. They're subconsciously or semi-consciously thinking about the relationship. They're flexible because that builds a good relationship. And so that's what happens, is they have these two different operating systems. One parent is transactional, and they're trying to get a benefit for themselves, right? And the other person is relational, and they're trying to build a relationship between them, their children, and the other parent. They're seeing everything as kind of being in a system. And so I think when I've helped clients understand that they're coming from a relational operating system, and the other parent has a transactional operating system, it's a mind frame shift. Mm-hmm. And they can start focusing on the transaction and making sure that the transactions there's more of a mutual benefit. And what I often heard when I was a mediator, and people would say it all the time, is to have a business-like relationship. What do they mean by that? They mean a transactional relationship where there's a mutual benefit that's achieved. I saw a patio set on sale at Walmart, right? And I was I want it because my stuff's old. and I want it. And so what happened was I am willing to give Walmart some of my hard-earned money so they benefit, and I benefit by getting this new patio set. We both walk away contented with the exchange, right? Walmart puts it on sale. They want to get rid of it. They're willing to take a certain amount of money. I want it. We both benefit. That's what business-like means. Walmart is a business. They don't, they're trying to have good relationships.
So Al, let me put this into like a real world example for you. And this is something that I figured out early on in my co-parenting journey, is that if my co-parent asked me for something, I had to think about something that I also wanted, right? He would say, I want to switch this day for this day. Okay, I'm willing to do that. I'd like to switch this day for this day. So can we put in an agreement that we're going to make a mutual switch and it's in writing and all that stuff? So what's interesting is, while that approach can work, I've also seen some people rope the protective parent in as part of the conflict when they participate in transactional things like that. Now, I've heard co-parenting coaches, and I've had co-parenting coaches early in my divorce process tell me to do exactly that. Well, if there's something that you want, ask it in return. And that, I think that can be really helpful when you're trying to advocate for your children's best interests. But I think that the line has to be drawn. I'll give you an example of one case that, I had a client where she was trying to get her son occupational therapy. And her abuser was saying, well, I'll let your son get occupational therapy if you do these 10 things on this list of demands that has nothing to do with our son. Right? That is the kind of coercive control that a protective parent is often dealing with. And so it's important to understand when to set the boundary and when to participate in that sort of transactional co-parenting, right? And make it really, really clear with an abusive, co-parent, I'm not going to do that when it doesn't involve the kids. No, I'm not going to modify the orders. No, I'm not going to reduce protect. No, I'm not going to. This is what I will talk about transactionally. And it's really helpful to have that boundary because, with co-parenting, and I'm sure you see this too, when we separate from an abusive partner, we basically have to re-educate them on what kind of behavior we will and will not tolerate now that we are no longer married to them. And so that process of setting the boundaries of, I will be transactional about this, and I will absolutely not be transactional about that is really important early on. But I love that using that transactional mindset to get your kids what they need, right? I love that.
Yeah. Well, for instance, with the Walmart thing, if I went to Walmart and the patio set was all messed up, right? That wouldn't work for me. I'd say no. So that's the bottom line is, your boundary is when you say no. Yes. And I think it's important to be clear about that. It's like, I'm not going to, this isn't acceptable to me and I'm not going to participate.
Yeah. Let me ask you a question. For parents who still have joint decision making with an abusive co-parent, how can they integrate parallel parenting into their co-parenting relationship? It's really tricky, right? If you have a shared decision making, but you need to parallel parent most of the time, in your experience, what does that look like?
Well, the parallel parenting means that you only interact when you absolutely have to, right? So that means, if the other parent is asking about flexibility, then there's an answer that is already there. It's like, no. If you're not keeping the interaction and the joint decision making to a minimum, you're not really parallel parenting. So if you are parallel parenting and you need to make a joint decision, you need to be clear about what are joint decisions that are required by your custody order. And I think they're usually fewer than most people understand, right? And they're in a good custody order, a consent order, whatever you got, agreement. Some countries are calling it a parenting agreement or parental agreement. No, they don't like the custody part. But what does it say? It's usually education. So if you're changing the school, that's
Bingo. That's
Yep.
it. It's not day-to-day
Medical-
educational stuff like homework.
No, it's not, or even tutoring. If it's not on the other parent's time or it's not on your time, it's not, that doesn't do it. So it could be, if your child needs tutoring, if that's on your time, your weeks or your days or whatever it is, you don't have to ask the other parent. That's not an educational decision. Medical care. So this can be a little dicey. I've seen cases where one of the parents did not want to get their kid immunizations, right? And so what I'd always say is, so think, now in mediation, you can do this. So think about this. If it doesn't work here, you're going to end up in front of a judge. What's the easy thing for the judge to do? The judge is going to order the immunization.
Yeah.
Every time. Unless there's a clear religious objection. As far as schools go that require immunization, that's their standard. Now, some people get around that, but so that's that thing like that. Medical care. It isn't, whether or not your kid has an appointment, it's whether you change the doctor, it's whether there's a new treatment, right? It isn't just going there. It is an emergency treatment. If your kid has the flu and is running a temperature of 103, you get to take them to the doctor.
Yep. And what are the boundaries? I tell my coaching clients, you need to have a canned response that you send for this because, there are different dynamics with abusive co-parenting. One of them is just the stonewaller. They don't respond to anything. They're not actively participating in co-parenting, and yet they have an opinion about everything, right? And then there's the people that are constantly wanting to insert themselves into the other's parenting time. They are dominating. They want to say in every little thing and they want to rope you into every minute conversation. And for those parties, that's typically the one where parallel parenting boundaries are really, really critical. And I have my clients literally a canned response. As this does not involve a major decision for the children, I will choose to parallel parent on this issue, right? And that's it. Say as little as you can. The fewer words you use, the better. Give them less to argue with, because if it doesn't involve a major decision and it's a conversation that you can have with your child in the home, let's say they got in trouble that day at school. Well, you can have a conversation with the child at home in your home and allow the other parent to have a conversation with the child as well. They're going to parent how they parent. You're going to parent how you parent. You're never going to agree on things, right? So what's the point in having a conversation about how you're going to talk to a kid about something challenging that happened at school when, they can't even agree to use the same lunchbox as, you, right? There's no rationalizing with an irrational person. And so I love that you talk about major decisions only, and that's it, right?
Yeah.
Yep.
Yeah. Well, there may come up there may be a family wedding on a certain weekend and you need to change it or something like that. But it's not day-to-day mundane stuff. And I think what's happening then, you're not really truly parallel parenting. You're trying to find a way to more transactional parent. I don't think there's anything wrong with that unless you're not learning from your mistakes, right? That's what I think is the issue, is that when people keep trying a certain tactic or strategy and it keeps failing, they need to take note of that. So that's one of the things that I think I would urge people to do, is to think about how many times are you going to try something before you realize it's not working. And that's, I don't think it's anything wrong to try to go from parallel parenting to transactional parenting to more, cooperative parenting. I think that's been a mistake that professionals have made, that here's parallel parenting, that's it, go do it. Is communicating a goal for both parents to be able to be more transactional, to be able to be flexible if it's possible. Learn how to.
Mm-hmm.
People can learn and grow. Yeah, and one thing you said about having a canned response, all those things have to do with boundaries. And I think boundaries sometimes are misunderstood. The boundary is not affecting the other person. That's a limit. The boundary is self-discipline and having a certain canned response that you know that you're going to do in certain situations, or let the other person know, I do not respond to any texts from you after 8 p.m. I need 24 hours notice before I do this, that, and the other thing. That's saying what I will do. That's self-discipline. A limit says you can't text me after 8 p.m.
Yeah.
That's different.
Right.
So, so the way I think of it is there's boundaries, which is self-discipline. There's limits that people put on. You can't do this. I won't let you do this.
Mm-hmm.
And there's constraints, which society or institution puts on it. The custody order is a constraint on the two parents that is imposed by the court.
Yeah. Yeah. And I think all the things that you were saying too about like, there are no text messages outside of these hours, or we will only text in an emergency. On another Lunch and Learn event, I spoke with 2 attorneys here in Colorado about drafting a manipulation-proof parenting plan where all those boundaries and limits are predetermined in the parenting plan so that you don't have to go back and talk about them later. Because like you said, I love the idea of growth. And Al, I am hopelessly optimistic despite what, the almost 7 years of abuse that I have experienced at the hand of my abusive co-parent. And despite the circumstances, how they are for many protective parents and what they're dealing with on a daily basis, I still have hope. And I believe in hope because otherwise there is like, what are we doing here? Right. And so what I always tell people is high conflict situations require high structure, and having that structure put in place in a court document is really key. And then you can always be more flexible from there. But having that high structure, really boundaried parenting plan as your boilerplate that you can fall back on if you need to is key, because, you're never going to get an abusive co-parent to be more boundaried. Right? That's never going to happen. But if you can fall back on your parenting plan, it's great. And then here's the danger that I see a lot of the times is if protective parents try to be more flexible, try to be accommodating, try to build in more cooperation, the abuser will then use that and go to the court and say, see, he or she was willing to be flexible on this once before. I want a parenting plan change. Or they clearly don't think that's actually really necessary boundary. So why do we need it? I want it removed, right? And so what they do is they take attempts to be flexible and cooperative and they weaponize them in the eyes of the court. Have you had experience with that?
I have, but I have a different impression that, first of all, only a certain percentage of cases get in front of a judge, right? Even the show causes and the modifications and whatever. So like when you say having a highly structured parenting plan, that would be something negotiated through attorneys in terms of a consent order, right? So then both parties have to agree to it, and the attorneys have to think that, advise that this is good in this situation. So I think that's a good way to go. But I think you need to keep that in mind. Like this, it's a consent order. If you're going to settle out of court, it's either going to be through mediation or through negotiation. And that means both parents have to agree to it. So it can't be so complex that no way is the other parent going to play. The other thing is it can't be so complex it can't be enforceable. Like in other settings I've had 100-page contracts, right, between the state of North Carolina and the organization I was working through. And I had to know that contract. And some of the problem was that some of the parties to the contract didn't know all the elements of the contract. So that's a risk with that, is making it too complicated makes it hard to follow and enforce. the other thing that you're saying is, does that play to judges to say, oh, the other parent was so flexible that this isn't really part of it? I don't know. I only know the judges around here, and that would not fly. So they may try to do that, and they may use it as an excuse for modification or get their attorney. But I think the question is, what's the judicial standard? And the judicial standard allows for flexibility, right? All of the decent orders that I saw, all of the orders that I wrote, all the judges' orders allowed people to be flexible. Unless, they'd say, this is it unless both parents decide, or some version of that, right? Thus ordered unless. So even the highly structured ones probably have something in there that says that the parents can agree. There's exceptions to that when when court orders have a protective element to them because one of the parents is a clear danger to the other parent, or more commonly the children. Right? Then it's different. Then the more rigid structure. But in most cases, that's not true.
So candidly, Al, that's the majority of clients that I work with is one parent is coercively controlling, and the abuse is insidious, and it is all consuming, and you can't call yourself a good father and terrorize the mother of your children, right? That's not a safe environment for the child. And so that's
but again, I don't push back a little bit, but where does that fall on? There's a continuum. I have it mentally that goes from, kind of a influence modeling like you do for your kids. You model good behavior for your kids, right? To persuasion that gets into manipulation and coercive control, and then gets into violence, threats of violence or actual violence, things like that, right? Those are all things that impact one of the parents' agency. So in that middle ground of manipulation, coercive control, that's not appropriate for a protective order. The protective order that I'm talking about, when custody orders have those components, it's because of threats or actual violence. Like there's some violence so the kind of order that you're talking about that's clearer, more structured, that's a good order for the situation with manipulation and coercive control. But again, my experience is limited, but in my limited experience here in North Carolina, that would not, the parent has to really be a threat to the other children, and there has to be evidence of that. It can't just be an accusation. There has to be clear evidence. So it's a pretty high standard. That may not be true in Colorado, and may not be true in other places.
Do you have laws about coercive control on the books in North Carolina? Is coercive control? No. Okay. No. So in Colorado, we do.
You do? Yeah. Another place, I think Maryland has a law about coercive control that it is a form of. So other states, North Carolina's more conservative.
Yes. Hopefully it'll reach it, because that's really the cases where you need really structured parenting plan, because for the people in non-physical intimate partner violence dynamics, those are the parents who are still experiencing abuse, and often the abuse intensifies when the target escapes the relationship. Physical abuse, yes, it's highly traumatizing and it's damaging and it's terrifying. When there's physical space and a protection order, one would hope, and sometimes this is not fully the case, but escaping the relationship can provide more physical safety once you're no longer in the home with the abuser. When people are in non-physically intimate partner violent situations, then the abuse just gets worse when you leave. Post-separation abuse is far more intense.
Right. And I work for domestic violence and sexual abuse service agency, so I get that. But that's not, if it rises to that level, that's beyond my purview. Right?
Got it.
In this situation, right? That it is definitely true. If there's credible threats of violence, if there's incidents of violence, then that's a different route. There needs to be a protective order. There needs, there could be criminal court involvement, and then it should be taken into account when a judge is hearing a custody case, for sure. And if it was at that level as a mediator, we would say a judge needs to hear this, right? Because there really is an evidentiary standard that needs to be achieved to be able to incorporate those standards. Because, for most, I don't know how it is in Colorado, but, for here, protective order is only going to last for a year, maybe 2 at the most. And the custody component only lasts for the first year, can't be renewed. So, but a custody order is not supposed to be renewed every year. Of course, people modify them, but it's supposed to be really as long as the children are in their minority.
Right. Exactly. Yeah. And so you're saying that that's sort of where your work ends. That's where my work begins, is supporting protective parents who are in those non-physically violent relationships, dynamics to protect their kids. And as in mediation.
Yeah, so we could have a conversation about that another time, because I don't know what you mean by non-physically violent. And I think that would be helpful to have a discussion about that, because I do have a foot in both worlds.
Yeah. Let's talk about that. That's a good topic for another day too. Non-physical intimate partner violence is a huge aspect of the work that I do with my clients. You talk about moral injury, Al, and I just want to chat for about 5 more minutes, and then I want to open it up for questions, because I'm sure we're going to have a ton of questions from the audience. But you talked about moral injury and growth in abusive co-parenting dynamics. Can you talk a little bit about that?
Yeah, and that relates to, and I'm going to drift a little bit away from that, but moral injury is the idea that that there's just not a sense of fairness at play, right? That the playing field isn't really level. And so in terms of what I think of judicial interventions around custody and co-parenting, right? Not just courtrooms and judges, but attorneys, parenting coordinators, custody evaluators, therapists, mediators, coaches. There's this whole ecosystem of professionals, and you see it. One way you really see it is in, say, co-parenting classes, where the idea is that, well, if you just build people's skills, if you just build their awareness and you just build their skills, they'll be able to get along better. Right? They'll be able to co-parent better. And for a lot of people, that's true. They just don't, they never experienced it. Nobody really didn't learn it in school. And so learning some skills around communication and conflict management and parenting stuff is helpful. But for a lot of people, it isn't. And the issue is that there's this underlying assumption. There's this really an unconscious social and institutional bias, which I was talking about before, is that the title of your thing, Take Two to Tango. And so when we don't make good as professionals, as institutions, as a society, on the idea that it isn't always two tangoing, right? That it isn't a level playing field, that it isn't balanced, there's this moral injury, because it means it's not fair. And what happens is that's advantaging the more manipulative, coercively controlling parent, right? Who might use some, legal avenues to control or impose penalties on the other parent, the communication, just the whole relationship. And so there's a sense of moral injury that people feel, that they're not being heard, they're not being respected, that and that it isn't balanced, and things like neutrality or those kinds of approaches aren't adequate to that situation. And so there's this, I call it a bias of balance in custody, where judges, mediators, especially parenting coordinators, custody evaluators, come in thinking neutrality is really important here, and it is, but it can't be, the end. It can't be. It's not enough.
And it's harmful in situations where there is an abuser. The words of Ellie Wessel, Holocaust survivor: neutrality helps the oppressor, never the victim.
Yes,
Silence encourages the tormentor, never the tormented, right? So when there is a high conflict, or like you like to say, I love this term that you coined, asymmetrical conflict, neutrality is harmful.
It is. Yes,
yeah, and it's re-traumatizing.
It's not interpersonal at that point. It's institutional and social. That's the difference. That's what people don't realize. And so something I happened on recently and that I think addresses some of the moral injury is something that is called a social witness. So social witness is a term that's used in social justice. It's someone in the community noticing that there's unequal treatment, right? That people of color get pulled over by police more. Excuse me. And so the social witness in this context is somebody who is validating the experience you had, the lived experience you had, the experience of some of our clients. That's a big thing that coaches do. That's a big thing I do for my clients in these situations, is say, no, it's not. You're not hallucinating. You're not imagining this. You're not paranoid. It's really happening, and it happens. It's not. I'm not saying it's the most of the situations, but in a lot of situations, one of the parent, for one reason or another, is driving the conflict. And having social witnesses of various kinds, friends and family, often can play that role. But, us as professionals, whether coaches, mediators, attorneys, to understand that this happens, that there's a certain dynamic going on, and that the party who is subject to the manipulation or control, the conflict, has an experience that needs to be recognized and validated. And that's where it comes. That's the way to address the moral injury, is to bring in some witness that it is unfair, that it is unbalanced, uneven, asymmetric.
Yeah, that validation is the first step to work toward healing, right? You can't heal if you feel like nobody understands what I'm going through, right? Brene Brown, the shame researcher, talks about shame is like, it's only me. I'm the only one going through this. And when you validate the experience of a domestic violence victim survivor, even those in non-physical intimate partner violence dynamics, that validation, that social witness that you're talking about, is the first step to, healing. Oh my gosh, it's not just me. Oh my gosh, you just described the situation that I'm experiencing. Like when I heard you speak, like when I heard, domestic violence advocates speak. And then you move it into what you talked about, which is what I like to call radical acceptance. The radical acceptance that the situation is what it is, the likelihood, right? That's the boundaries. There's nothing that is ever going to change that abusive co-parent, ever. So what can I do to shore myself, to create boundaries, to set limits, to advocate for my children? What can I do behind the scenes to take care of myself so that I'm resilient for the journey of however long it takes my child to get to age 18, right? Whatever that is. And I think that that's a big part of it for so many of my clients. When they stop fighting the situation as it is, when they accept the situation for what it is, they're able to reduce anxiety and stress, reduce reaction, and, be more intentional about how they respond to their co-parent. Which isn't just, it sucks. That's just the reality. Having to co-parent with your abuser is cruel and unusual punishment, And so, but I think that that's a big part of the healing process that has been helpful for so many of my clients, accepting the situation for what it is. Okay, now what am I going to do about it? How am I going to take care of myself, my children? How am I going to protect my heart and heal? Who can I surround myself with? Right. And I think even having these sort of validating conversations like we're having today is a huge part of that piece. So we have one question in the chat that I want to address. And if anybody else has questions, I want to be mindful of Al's time. So we have about 9 minutes left. I see the question. Are there any tools you can share to undo the manipulation my teenager is being subject to every day? Is there anything I can do to help her? She's being lied to on a daily basis and is completely aligned to the offending parent. This is not a co-parenting situation. I'm under counter-parenting at every turn. I am, first of all, I'm so sorry that you and your daughter are going through that. I have a resource that I would love to share with you right away, and then I want to hear Al's perspective. There's a coercive control specialist. Her name is Dr. Christine Cocciola. Her last name is spelled Cocciola. And she teaches a protective parenting course for parents whose children are being manipulated by the abusive parent. All the way to the children are completely aligned with the abuser. They come home parroting, abusive language from the abuser. How do you deal with that as a protective parent in your home? What strategies, she gives you specific strategies for how to respond to that child without getting sucked into a reaction that the coercive controller is teeing you up for, right? So how not to play into that trap. She's a godsend. I have taken her protective parenting class and I cannot recommend it highly enough. The live cohort especially is more expensive, but you get so much out of the other parents sharing, and it is primarily women, but there are a few men in the class as well. But I got so much out of the other parents sharing, and I can't recommend it enough. Dr. Christine Cocciola of Coercive Control Consulting. Al, any tips there?
Well, I think there's, like you said, there's other people, there's other professionals who really focus on these kind of manipulation, refuse and resist tactics for children, and they're much better at that. I really focus on the relationship between the parents. Not that I don't sometimes give parenting advice to my clients, I do, but so that's not my focus, is the relationship between the parent and the child, which is really what you're talking about. Mm-hmm. The one thing I'd say that, what cuts across all of this, coercive manipulation, coercive control, domestic violence, is an effort to undermine the other person's agency, right? That's the one thing that cuts across all of it. And so what you need to do is to reinforce your own sense of agency. What can you control? And I think that's the radical acceptance, is that the only person I can control in this situation is me, and that I am far from having the optimal sense of control that a human being can have over themselves. Mm-hmm. And that's what I think is I mentioned this before. There's two things that I help people focus on. One is intentionality, which is to be intentional in all your interactions with the other parent. And the other thing is emotional literacy, mm-hmm. Understanding your emotions, where they're coming from, how they work, how they're evoked in the situation, and how you can manage them. You are not your emotions. Mm-hmm. And that's something that a lot of people don't realize. You are not your emotions. Your emotions, you aren't sad, you're feeling sad. Right. You're not mad, you're feeling mad. And once you get that idea, then you can start managing your responses. Yeah, in a better way.
Have you heard of Brene Brown's? Well, actually, I think Robert Kiyosaki was the originator of the idea, and then Brene Brown built on it. The above the line, below the line model. Are you familiar with that? Mm-hmm. Yeah, that's something we talk a lot about in with my private coaching clients is how to identify. So the line is fear is the idea.
Mhm.
And how to identify when you're above the line and when you're below the line. So when you're above the line, you're aware that you're feeling fear or hurt or anger or whatever it is, but you are still driving the car. Your anger, your fear, your hurt are not driving the car. You are driving the car, and fear is in the back seat, and you're going, I know you're there. I'm still in control of my behavior. When you're below the line, you are in the back seat without your seatbelt on. Fear's driving the car, you're flying all over the back seat, and you are just you are largely unaware of your behavior because you are letting your emotions drive the car. And so that's part of what we talk about too, learning to identify, okay, I'm below the line here. What do I need to do? Right. And so for, my clients, we talk about my emotions are activated. My heart is beating fast. There's tightness in my chest. I feel nauseous. I feel dizzy. My face is getting red. What are the feelings in my body that show me that I am below the line? And when you know you're below the line, stop. Do not respond at all. Sleep on it for 24 hours if you can. There's actually science that proves that your brain can problem solve conflictual problems a lot better after a night's sleep. Stop, sleep on it, wait, respond the next day, wait on your response, read it over and over again, give it to a friend to read, right? So there are ways that you can manage a completely unmanageable situation, because the worst thing for protective parents is when they lash out and respond to their abuser, and then their abuser grabs hold of that response and they just weaponize it until the end of time. There's nothing worse than that regret, right? Yeah.
That's how it becomes mutual conflict. One person's aggressive, the other person's defensive, right? But what we were talking about, I went to kind of a rough and ready high school. There were a few fights. It didn't matter who started the fight. Both of the kids got in trouble.
Mm-hmm. Mm-hmm.
So one of the things to realize if you're thinking about emotional literacy is, you mentioned fear. Fear is a primary response, right? It triggers all these secondary responses that we experience, like anger and anxiety, right? Even depression is a lot of it's coming from fear. And so that's a threat response. Our bodies are set up to respond immediately to a threat. That's what you're doing. You're responding to something you're perceiving as a threat, right? But your rational brain's a lot slower. It isn't wired to respond to threats like that. It's wired to respond to problems. And so that's the difference. That's why the pause is so important. Your body is experiencing something that's a threat, and all the somatic experience you described has to do with the threat response, and that has to pass.
Mm-hmm.
Once you're feeling under threat, it's really hard to think clearly about.
Yeah, because your body doesn't know the difference between there's a bear in the room and the bear is on the other end of the computer typing nasty grams to you, right? Your body can't distinguish between those two things. Yeah.
Well, your mind is responding to them differently, right? It's not like it's not just a reaction. There's an interpretation that you're making when you read that text, that it's threatening and that you got to respond. So there's that part of it too. It's not like stepping on a snake. You're making an interpretation, and that's something else that people need to be aware of, that your interpretation creates the threat response.
Mm-hmm. Mm-hmm.
And so you need to challenge that.
Yeah. And then like we were talking about before today's conversation, understanding what actually needs a response and what doesn't. Mm-hmm. Do I actually need to respond to this message that my abusive co-parent just sent or not? Right. Mm-hmm. And like we were talking about, is if you're parallel parenting, it's not a major decision. It doesn't need a response. And then, to avoid the accusation that you're not engaging in co-parenting, you just send as this is not a major decision, I will choose to parallel parent on this.
Yeah, I think you can do that, or you can say, something about text is there's a certain urgency that people attach to text that was not there before.
Yeah.
Not with emails. And
Yes.
you can text, I got your text, I'll respond in the next 24 hours.
I love
It's
that.
not urgent. If your kid didn't break their leg, right? I'll respond in 24 hours. And that gives you time to process it. But you can't, if you interpret a communication as a threat and you're reacting as a threat, a somatic kind of reaction that's a threat, that means you're, like you said, your rational process is taking a backseat. You need to be able to get past that threat response to be able to allow the rest of your brain to start problem solving.
Exactly.
The pause gives you a chance to do that.
The pause. It's all about the pause. Well, Al, we are at time, and so I want to be mindful of your time, and I can't thank you enough. I am going to just keep trying to get you out here to educate some family law attorneys and other folks.
Oh.
You know, I'm not going to give up.
I'm happy to do the CLE. I've done some here, a couple here on the topic, and a couple on the topic of custody, and so I'm happy to do it. Just going to say that I'm going to be presenting with a couple of colleagues to the Association of Family and Conciliation Courts annual meeting in Seattle in May on this topic. So I'm always happy to communicate with people. Also, and just encourage people to reach out to me. I'm on LinkedIn a lot. There's my contact information. Reach out to me. I'm pretty open about discussing people's situations with them.
Al, thank you. That's, such a lovely offer. And to everybody here, please go ahead and take a screenshot of Al and my contact information there. We're both available for support and validation. Al, again, thank you so much. We will have another Lunch and Learn event on April 8th. With another financial minded coach. She's not a financial advisor. She's a financial coach, and she's going to be giving us tons of great tools to get our finances realigned post-divorce in a really accessible way. So I'm looking forward to that. Thank you for your time, everyone. And Al, thank you again. We'll see you at the next Lunch and Learn.